The Forest Department, in coordination with the district administration and the police department, have been forcefully evicting the peasants who have been in possession either by virtue of land grant and sagubali chit for the last 50 years, 60 years, 70 years and 80 years, and they have grown mango groves and cultivating the lands and eking out their livelihood. So, the right to occupation, agricultural occupation, is a fundamental right guaranteed under Article 19(1)(g) of the Constitution of India. Article 19(1)(f) was deleted, right to own private property as a fundamental right, by virtue of the constitutional amendment in the year 42nd Constitutional Amendment. That right has been kept in the Article 300, which is treated as a constitutional right. That constitutional right has been interpreted by Supreme Court in respect of the land acquisition cases that it is a human right. So, constitutional right is more than a fundamental right and a human right. Now, the Human Rights Act has been enacted by the Parliament on the basis of the signatory to the resolution of Stockholm, where what is the human right? The cultivation of the land, own the land, constitutional right, and cultivating the land and growing agricultural produce, horticultural produce, floriculture, etc., is a agricultural and a horticultural occupation, which is a fundamental right, it is a constitutional right. Constitutional right has been translated into human right. Now it appears in the Kolar district, Tumkur district, Chikmagalur district, the forest department has woken up suddenly to evict these persons who have been in possession under the guise of the notification of 1933, 34 and 37 issued under the repealed Forest Act 1900 during the Maharaja's rule. That notification has been completely abandoned by the Forest Department for the reason that they have not utilized those lands covered in the notification, which extent is lakhs of extent of land. The people have been in possession, recognizing the fact that the Forest Department has not utilized their right and grown the forest either as a village forest or a reserve forest or a ordinary forest under the Forest Act. That means they have abandoned their right in respect of the lands covered in the notification issued under the repealed Forest Act of 1900. The abandonment has been explained by the Supreme Court of India in Ketanov cases, particularly in the GT Lad case. Abandonment means the right, tethering the relationship between the land and the ownership by the Forest Department. When they have tethered their relationship with the land because they did not utilize the land as a forest land, they did not grow the forest in the area covered under the notifications. Therefore, the land was vacant. The Revenue Department stepped in, thinking that it has not been utilized. They have granted the land in favor of landless and small holders for the purpose of their livelihood. They have been in possession by virtue of the land grant order and sagwali chit, and they have been paying kandayam, and they have been growing. Some of the people are growing the regional crops like ragi, paddy, groundnuts, etc., on rainfall area. Completely depend on the rainfall, and some of the people have drilled the bore wells and grown the mangroves. Generation after generation they have been enjoying. The family members have been eking out their livelihood on account of cultivating these lands. Now all of a sudden the Forest Department forcibly cannot come and evict these people. The Supreme Court, following the Privy Council judgment in 1924, Midnapuri Zamindari case, they have clearly held that in India it is not permissible to evict persons who are in possession as a trespassers without due process of law. A due process of law means they have to file a suit and recover possession. In such cases, Section 64 has no application for the simple reason that the moment they issue notice is required to be issued. Even without issuing notice, they are issuing notice only in the WhatsApp of the land grant and the Sagavadi chit issued. And we have been in possession and we are paying Kandaya. We have been for the decades, more than 30 years. Limitation Act will step in. Section 27 of the Limitation Act clearly says that the Forest Department, the fact that they have not have been in possession, cultivated as a forest land, they have abandoned their right, therefore they have extinguished their right. The moment that the Section 27 right of extinguishment of the Forest Department, these people who are in possession of the land by virtue of the Sagavali chit and the grant order, these people have enjoyed tribal tests as envisaged, as laid down the Supreme Court in 2019. Supreme Court has said tribal test for the purpose of establishing perfected title by adverse possession. That is, they have been in possession, enjoyment as owner against the true owner, and they have been more than 30 years continuous possession. So these tribal tests have been passed. Once they take up a plea in the counter, if they issue notice that we have been perfected our title, the revenue officer will not have any right whatsoever to further pursue and pass order to evict them. They have to go to the civil court. If they go to the civil court, the plea of adverse possession is very much available for such persons who have been in possession of the land over the decades, more than 30 years. So therefore, the Limitation Act will step in and the constitutional rights are violated, and if the Forest Department, under the guise of the notification with the police aid, blatant violation of the rule of law, going and evicting them and cutting the trees which have been grown by the farmers, is a clear case of criminal act for which the Forest Department officers concerned are liable to pay the damages as has been ordered by Supreme Court in UP case, where unauthorized structures have been demolished in Uttar Pradesh. Supreme Court under Article 32 petition has directed the department, municipal administration. So High Court, based on the UP case, has to consider and pass the damages and restrain these people to further take action and harass these people. And criminal cases are lodged. Criminal cases also can be lodged against the government officers whose acts are criminal in nature, as they have not taking the possession of the land in accordance with law, because they are in possession. Supreme Court says that you cannot evict a person without due process of law, even if he is a trespasser. How can you do that? Is the Forest Department has got a separate law? The law governs everybody, citizens, as well as the government officers. Government officials will, under the guise of this state of Karnataka and this Nirvana Gowda's case has no application at all. Gowda case has no application. Nirvana Gowda case has no application. Gowda case has no application. How can these people take the law into their own hands and take possession? That is not permissible at all. So therefore, the elected government, democratically elected government, must take care of welfare of the people, particularly the peasants.
ಮೂಡಲಕಿರಣ ಯೂಟ್ಯೂಬ್ ಚಾನಲ್ ಅನ್ನು ತಪ್ಪದೇ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ, ಲೈಕ್ ಮಾಡಿ, ಶೇರ್ ಮಾಡಿ. ನಮ್ಮ ಮುಂಬರುವ ಎಲ್ಲಾ ವಿಡಿಯೋಸ್ಗಳಿಗಾಗಿ ಪಕ್ಕದಲ್ಲೇ ಇರುವ ಬೆಲ್ ಬಟನ್ ಅನ್ನು ಒತ್ತಿ.